Dear students, welcome to MOOC on the National Human Rights Commission. In the earlier module, we saw the Protection of Human Rights Act, and in this module, we will take up the structure, composition, role, important features of the National Human Rights Commission, and also how it carries out investigation or inquiry. It was established on 12th October 1993 under the Protection of Human Rights Act 1993, and which was subsequently amended in the year 2006 and also in 2019. What are the important characteristics or features of the National Human Rights Commission? It is a statutory body having been established under the Protection of Human Rights Act. In addition, it is a recommendatory body in the sense that it cannot issue binding orders or writs like the courts of law. Where it finds prima facie violation or where it finds an important burning issue relating to human rights, it can only make suitable recommendations to the concerned authority for implementation. In addition, it is compliant with Paris Principles, has a wide mandate, and it is also an independent body. And how is this independence ensured? The term of service of chairperson and members is fixed. For instance, it is 3 years under the amended Act in 2019. They cannot be removed at the whims and fancies of the government in power, and the manner of their removal is laid down in the statute. Their salary cannot be reduced during their tenure. So all these features give independence to the National Human Rights Commission. It also has the powers of a civil court while handling complaints of human rights violations. So all these features go on to make it a strong, powerful body which is needed to address protection and promotion of human rights issues in the country. Let us now turn our attention to the composition of the Commission as provided in the Section 3 of the Protection of Human Rights Act. Students, I wish to draw your attention to the graphic in this regard. Please follow the graphic for the current composition of the National Human Rights Commission. As you can see from the table, the Commission is headed by a former Chief Justice of India, Justice H.L. Dattu, who is the chairperson, and there are currently in addition to chairperson, 3 other members. Sri Justice Prafulla Chandra Pant is a member, Srimati Jyotika Kalra and Dr. Yaneshwar Manohar Mule are the members. There are 2 vacancies currently. In addition, there are deemed members, and as you can see from the table, the chairpersons of the National Commission for Minorities, SCs, STs, Women, Child Rights Commission and Commission for Backward Classes, and the Chief Commissioner for Persons with Disabilities are the ex officio members or deemed members, and they participate in the meetings of the statutory full commission. Section 3 also provides that there shall be a Secretary General who will be Chief Executive Officer of the Commission. The Secretary General can exercise all administrative, financial powers, subject of course to the control of the chairperson of the National Human Rights Commission. He cannot have any role in judicial functions or the power to draw regulations which are only with the Commission. Now, if you look at the structure of the NHRC, it is divided into 5 divisions. I draw your attention to the graphic which the 5 divisions of the Commission are given. There is a law division, there is an investigation division, and there is a administrative division and training division, and there is a policy research program projects division. Now let us take up law division. Law division handles all matters right from the stage of receipt of complaints of human rights violation, processes them and then places them before the commission for appropriate directions and follows up the action taken. It normally receives around 100,000 or 1 lakh cases every year. The law division is headed by a registrar who is supported by several presenting officers, one joint registrar and many deputy registrars and assistant registrars. Very important and high profile cases are placed before the full commission of 6 members, chairperson and 5 members, and instances relating to custodial deaths and other matters are often placed before division bench, and there are of course single member benches are there. The commission also has camp sittings at other places within India and where it handles matters. In addition to the law division, we have an investigation division in the National Human Rights Commission headed by an officer of the rank of Director General of Police, and this division investigates complaints which are referred to it by the commission, and it also monitors deaths in police custody, deaths in judicial custody and deaths in fake encounters or what are called extrajudicial executions. The administrative division of the commission handles all establishment matters, personnel, library, publications, computers and many other issues. The training division tries to sensitize people within government or outside government about issues relating to human rights. The training division also organizes short-term and long-term internship programs. The policy research program and projects division looks at research on important aspects relating to human rights and also monitoring the international human rights conventions and making recommendations to the government from time to time. The policy research division basically, whenever NHRC feels that a particular matter is of such importance that it requires sustained monitoring over the years, that is converted into a project. Say for instance, trafficking in women and children, quality assurance in mental health, or elimination of bonded labor or child labor or manual scavenging. Some of these matters require sustained continuous monitoring, and these are converted into programs and projects and entrusted to the policy research programs and projects division. Again, recall there are 5 divisions in the commission: law, investigation, administration, training and policy research division. So these 5 assist the Human Rights Commission in the discharge of the various functions which are provided under Section 12 of the Protection of Human Rights Act. I want to explain in some detail the complaints handling mechanism of the Commission. Anybody who is affected or a non-governmental organization can bring a matter to the attention of the Commission. It should ideally be a violation of human rights committed by a public servant or negligence in the prevention of a violation again by a public servant, or the matter could be referred by a court of law to the NHRC. A person who wants to complain can do so in a number of ways. He or she can file an online form that has been provided for this purpose, or send a self-contained letter, petition without the aid of any lawyer, or that person can also visit the commission and send a mail to the commission. It's very important to understand what kind of matters can be entertained by the commission and what cannot be. Basically, the matter has to come under the ambit of the protection of human rights, particularly the definition of human rights that is mentioned in the section 2 of the Protection of Human Rights Act, and only acts of omission or commission by public servants alone are the subject matter of the NHRC. In other words, acts of private agents cannot normally be brought under the commission. For instance, incidents which are more than 1 year old cannot be referred to the NHRC for redressal. There is a section 36 of the Protection of Human Rights Act, under which there is a time limitation which is there. These complaints become time barred and thus become non-entertainable. In addition, if the complaint is already pending before another commission, let's say Women's Commission, Children's Commission, or a Scheduled Caste Commission, or any other commission of inquiry duly constituted, or it is sub judice before a court of law, these matters are not normally entertainable by the NHRC. Now, let me explain the steps after inquiry. A range of options are open to the commission after inquiry into a complaint of human rights violation. Where there is a prima facie violation, the commission can recommend award of monetary compensation. It could even be interim compensation pending the conclusion of the inquiry. The commission can also recommend prosecution of the guilty or errant public servants involved in that particular incident. The commission can share its report to the complainant, and the commission can also publish its report of the human rights violation and also its own order. So these are, in addition to these, the commission can also approach as a Supreme Court or a High Court for issue of appropriate directions and writs. So these are range of options which are available to the NHRC after inquiry into a violation of human rights. Under Section 19 of the Protection of Human Rights Act, a restricted procedure has been provided for dealing with violations committed by armed forces personnel. Now let me take you through a list of illustrative cases. In the first case, we will look at what the commission did in the case of death of civilians in the Bijbehara. It is the first case taken by the NHRC soon after its establishment in 1993. In this incident, there was an unprovoked firing on unarmed civilians by border security force personnel, which led to the death of 60 civilians, and the commission took suo motu cognizance based on newspaper reports, called for reports from the concerned agencies, and thereafter recommended action against the errant BSF personnel under the BSF Act, payment of compensation to the next of kin of those who died. The NHRC also said the deployment pattern of BSF personnel should be reviewed, particularly when they are asked to operate in civilian areas. Now, let me take you to yet another case involving Chekma and Hajang refugees in Arunachal Pradesh. These persons fled the then East Pakistan and settled in Arunachal Pradesh in response to complaints from People's Union for Civil Liberties, Amnesty International and others. The National Human Rights Commission made a series of recommendations to the government of Arunachal Pradesh with a request to or to protect the right to life and property of these refugees. When the commission found that there was a unduly long delay or a protracted delay on the part of the state government in implementing these recommendations, the commission took up a petition to the Supreme Court of India, and the Supreme Court gave directions to the concerned state government and others to ensure that the right to life and property of the Chakma refugees is protected. Gujarat riots happened in the year 2002, in which many persons of a Muslim origin died, and there was a loss of homestead and other property. The commission took fact-finding and based on that made a series of recommendations to the government of Gujarat for rehabilitation of victims and also for detailed investigation of each of these cases. When it found that there was lack of action, the commission was constrained to take the matter to the Supreme Court of India, and thereafter in a number of cases a positive action has happened and the victims have got some relief, and the courts also have been able to prosecute a number of persons responsible. Let me draw your attention to a right to food case in Orissa. About some 2 decades back, there was in what are known as KBK districts, basically Koraput, Balangir and Kalahandi districts, there was reports of starvation deaths, and the commission sent senior most persons for on the spot investigation, and thereafter the commission asked a special rapporteur to monitor the situation. And in the Orissa starvation deaths case, the NHRC made a series of short-term and long-term recommendations to the state government and the central government, particularly with regard to the public distribution system, employment generation program, irrigation programs, agriculture programs and many other programs, and the sustained monitoring by the commission has led to some positive impact on the ground. In addition to these, there were a matter relating to Punjab mass cremation was referred by Supreme Court to the NHRC for monitoring, and the commission also went into atrocities committed by special task force personnel constituted by Government of Tamil Nadu and Government of Karnataka to nab the sandalwood smuggler Veerappan, and particularly the tribals became victims in the process, and the commission made a record compensation after fact finding on the ground and after ascertaining the facts. In addition, the commission has intervened in many cases involving child labor, bonded labor, violation of the rights of women, children and other sections of people. In this module, we have seen the structure, composition, role of the NHRC and also its important characteristics and some important cases taken by NHRC. Thank you. See you in the next module.